Good morning. My name is Lawrence Mcnamara. I'm the Deputy Director at the Bingham Centre for the Rule of Law. It is very much a pleasure to be here, and thank you so much for coming along to the start of day two. On behalf of the Centre, on behalf of Jones Day of FGV School of Law, Sao Paulo School of Law, along with the Inter-American Dialogue, I'd like to welcome you to day two, where we have a range of outstanding expert speakers across 4 panels for the day. The first of these in a few moments will look at judicial independence and accountability. The second at tackling and prosecuting corruption. The third at the rule of law in unequal societies. And the fourth will look at the due process and the role of the legal profession. And before moving to the first, I will just cover a few very brief organisational matters. The program, if you're not already aware, is on the inside of the paper in your name tag. The conference materials, including the speaker biographies, the delegate list, and several of the papers and reports are available on the USB stick you will have received. They're also on the conference website, for which the quick link is www.bit.ly/Brazil-2016. Or you can just Google the conference and that will come up. If you're using Twitter, you can tweet to the hashtag rule of law. And so with that, I'll turn then to our first panel on judicial independence and judicial accountability, and to welcome our 4 speakers. The panel, of course, picks up themes that run throughout the conference. And the role of the judiciary as an institution and as individuals who decide cases is, of course, profoundly important in understanding, in building and in maintaining the rule of law. And yesterday, former President Cardoso captured the importance of this in Brazil when he said in what I found just such a striking phrase, that people no longer know who the military are, but instead now know the names of the Supreme Court judges. And that, while people in this room, possibly like myself, love knowing the names of Supreme Court judges, that is a hobby. It's a great thing when this really engages the public and that relationship of the body politic with its courts and with its higher courts. The respect for the judiciary and the confidence in the judiciary, both institutionally and individually, is vitally important, and so equally as an understanding of how judiciaries come to be as they are and how they function and are seen to function. And that brings us to the panel, and today we're fortunate to have 2 new reports being launched. The first of these is a report by the Bingham Centre, and this was published on Sunday. The second is by the International Bar Association's Human Rights Institute, and that's been published today. The reports are available on the conference materials. There are a limited number of hard copies available. If there's none left on the table, come up and see myself or the presenters after the session, and hopefully we'll be able to find one. What we'll do is have the author of each report speak, immediately followed by a commentator. And then after our 4 speakers, we'll open the floor to questions. I'll just do one introduction of our speakers all in one go now. The first report is Judicial Independence in Latin America, the Implications of Tenure and Appointment Processes. And the report by the Centre, Bingham Centre, comes out of some discussions over a year ago with Jose Antonio Munoz of the Central American firm Arias and Munoz, and they have supported the research, and without that support, that project would not have been possible. And I might add also that Jose Antonio facilitated the links between the Bingham Centre and the Inter-American Dialogue, who presented such a great panel yesterday. And the speaker for that report is the author of the report and my colleague Jan van Zyl-Smit. Jan has worked very widely on judicial appointments and tenure issues, and he was a key person behind the Cape Town Principles, which you'll find in the conference materials in English, Spanish and Portuguese. And the commentator will be Julio Rios of CIDE in Mexico. The second report is titled A Double-Edged Sword, Judicial Independence and Judicial Accountability in Latin America. And the report from the IBA's Human Rights Institute sits within the wide range of their work in the Americas. And some of you will be familiar with the Torture Prevention Toolkit for Brazilian judges, prosecutors and defenders, which was launched in Rio late last year. And this report was written by Jessica Walsh, who will be our third speaker. A lawyer and researcher, Jessica has worked across Latin American issues, though has been doing in-depth doctoral work in Argentina. And the commentator will be Professor Luciana Ramos of the Sao Paulo School of Law, FGV. All our speakers have been asked to keep to time, and you may occasionally hear me tapping a glass as a hint that that time is coming to an end. With that, thank you very much, and I will welcome Jan van Zyl-Smit as our first speaker.
Good morning, ladies and gentlemen. Thank you, Lawrence. It is a great pleasure to be here in South America and Brazil for the first time. And I would like to add to what Lawrence has said on behalf of the Bingham Center and express my own gratitude and appreciation to Arias and Munoz for funding the research that I'm presenting here today. As Lawrence mentioned with the Cape Town principles, my experience of studying the judiciary has been mainly in Commonwealth countries with a common law legal system. From the perspective of an outsider, therefore, I find it fascinating to see how the same universal issues are debated here. And I'm delighted to be sharing a panel with distinguished experts on judicial independence in Latin America. If my terminology occasionally lapses and I start talking about appointment commissions instead of judicial councils, please forgive me. In his opening remarks yesterday, Professor Oscar Vieira of FGV said that the rule of law is in some ways an emotional concept. And he explained that everyone feels it is a good thing, but sometimes the understanding of what it is and how precisely to put it into practice is lacking. Perhaps the same is true of judicial independence. Most people agree that judicial independence is valuable, but that does not mean that we should not examine it more closely and consider what it is that we are talking about and why we value it. Now, we've tried to do this in the Bingham Center research here and in our other work on judicial independence by distinguishing between three senses of judicial independence. The first, and perhaps the most practical sense, is the actual independence of judges who adjudicate without showing fear or favor to anyone, including the government. Now, actual independence is clearly necessary for the rule of law, but it is not the only kind of judicial independence that matters. There is also the perceived independence of judges or of the judiciary as a whole, which gives members of the public the confidence to submit their disputes to judicial resolution. Now, it may be quite easy to overlook this, but perceptions of judicial independence are also necessary to the rule of law. If people do not have confidence in the courts, they will not cooperate with justice systems if they're victims of a crime or if they have a civil dispute, and instead some may take the law into their own hands or turn to violent groups to protect them. Finally, then, there is the third meaning of judicial independence, which refers to legal safeguards, such as security of tenure in office, appropriate processes for appointment and discipline, the protection of judicial salaries, budget guarantees, administrative autonomy, a range of matters which Ministro Mendes addressed yesterday in his lecture. Now, lawyers and constitution makers sometimes talk about these legal safeguards, the third sense of judicial independence, as if they are the objective. But in fact, the better way of looking at these legal safeguards is that they're not ends in themselves, but rather instruments to strengthen the actual and perceived independence of the judiciary and thus the rule of law. For example, we do not guarantee high and non-reducible judicial salaries because that is what every judge deserves. We know that, in fact, there will be some who work harder than others, and a few judges, hopefully only a few, who may be incompetent. The real reason for protecting judicial salaries are the benefits that result for the rule of law. Better candidates may be attracted to the judiciary. Those who are appointed will be less vulnerable to governments exerting financial pressure on them and less exposed to the temptation to supplement their income through corruption. So their actual independence, in the first sense, is likely to be strengthened, and also their perceived independence, as the public can see that the protection of salaries prevents judges from being exposed to such conflicts of interest. And I'll come back to those conflicts of interest because that's an aspect that we feel has not always been highlighted in the international and especially regional approaches. So I've mentioned there some of the most common legal safeguards, and it is important to say that they work together as a package. If you put all of those safeguards together, as constitutional advisors now do when judicial provisions are being rewritten, that is probably the best way to maximize actual and perceived independence. But for the purposes of today's presentation and in our report, we've chosen to focus on two of the classic protections, and those are tenure and the processes by which judges are appointed. So in the report, you'll find that the approach we take is international in the sense that we set out international norms, and also comparative. We then look at approaches in countries in this region and the regional institutions that exist. Let me begin with the international norms on the tenure of judges. So the United Nations Basic Principles on the Independence of the Judiciary declare that judges shall have guaranteed tenure until a mandatory retirement age or the expiry of their term of office, where such exist. So this means that the basic principles permit both fixed-term appointments, those are appointments until the expiry of the term in office, and permanent appointments, by which we mean until a retirement age. But in more recent years, since the principles were adopted as a global compromise in 1985, international opinion and practice has shifted towards permanent appointments. In our work looking at all 53 Commonwealth states, we found that over 90% make provision for permanent appointments, and it's only the very small states that rely on fixed-term judges, small islands in the Pacific, for instance. Now, the African Commission on Human and People's Rights also recommends that there should be no fixed-term appointments, and instead permanent ones. And the Council of Europe's Commission for Democracy Through Law, the Venice Commission, argues that appointments in the civil law systems of Europe should be permanent, with the specific exception, in some cases, of judges on a specialist constitutional court who may be appointed for a fixed period. It's interesting to look at the approach of the Inter-American Commission on Human Rights, one of the leading monitoring bodies in this region. So the Commission recognizes that an established and sufficiently lengthy term gives the justice operator the sense of job stability, and goes on to talk about the protection that this gives against pressure. And in that, I see that the Commission recognizes tenure as a source of concern, but we don't find that they go on to insist on permanent appointments. And this is quite an interesting feature of this region in particular. So while those concerns are completely understandable and a longer term will help to avoid actual independence, our question is, why not avoid the conflict of interest completely through a permanent appointment? But it's quite likely that the Commission's approach is adjusted to reality in Latin American jurisdictions. Permanent appointments are very rare at the highest level. Brazil and Argentina and Chile are the three leading examples where the Supreme or the Supreme Court really has such appointments. And concerns also exist in the lower courts. But at the same time, while permanent appointments are not the norm here, there are some innovative responses to securing judicial independence in this area. So automatic renewal of appointments is one, seen in Costa Rica, where Supreme Court judges serve for 8 years, but they will be reappointed unless a 2/3 majority vote against in the legislature. This is clearly very close to a permanent appointment and has been approved by the UN Special Rapporteur. A second and a third approach are either to prohibit reappointment, as in Colombia, or to allow reappointment, but only after the judge has been out of office for some time, and Uruguay, among other jurisdictions, does that. Now, the Inter-American Commission puts these forward as examples where, if the period of appointment is long enough, this can secure judicial independence. The question that I've already posed, just to elaborate on that, is why not eliminate the conflict of interest? Because although a judge who's approaching the end of their fixed term may not be looking for reappointment, they may have reasons to look for other forms of employment or favors, either from the government or from private interests. So there is this conflict that remains even if there are such restrictions in place. Now, very briefly, the security of tenure concerns in the lower courts center around temporary judges. So although there's a career judiciary for people who do secure full appointment to the lower courts from a young age through until retirement, in many cases, jurisdictions, and the worst, I think, is Venezuela, don't formally appoint someone as a judge. They appoint them temporarily or provisionally, and that means that the judge's period as a judge may come to an end without any disciplinary process in some cases. Clearly, an even weaker protection than the fixed term. Now, in the interests of time, I'm going to proceed. How much do I have? Oh, thank you. Let me then, I'm glad there's some time to talk about appointment processes. This is an area in which international norms have really been developing very rapidly in recent years. So it's long been clear that appointments must be made without discrimination, and the UN Basic Principles call for appointments to guard against improper motives, and by that we understand corruption or patronage. But it's only quite recently that detailed guidance has developed as to how this should be done, how an appointment process should be designed to well, among other things, secure judicial independence in the senses that we're focusing on. So the 4 aspects of international best practice that we're highlighting in this report are detailed criteria to promote selection on merit in the sense of the judge's suitability, the candidate's suitability to be a judge, and also to allow the process to consider diversity and a more gender balanced, a more nationally representative judiciary. Then the need for an independent appointment body such as a Judicial Council to depoliticize the appointments. Further, that body should carry out rigorous and fair assessment of candidates against the published criteria. And then finally, transparency, something we heard about a lot yesterday, to both prospective candidates and the general public. And I want to dwell a little on transparency because I think that's a very exciting development in relation to the judiciary. Transparency, you might think, is mainly of use to achieving perceived judicial independence. And certainly what it does is to expose the way in which judges are appointed to the public so that there isn't a belief that these are simply the choices of the executive government. There's the steps in the process and the criteria are made transparent. And sometimes more. Sometimes there's an opportunity for civil society to scrutinize named candidates. The shortlist is made public and civil society can voice objections. A further hearing is then held in public, and Latin America has, to some extent, led the way in doing this. Now, all of that goes to strengthening perceived independence, but a point that I would like to highlight is, in fact, it also contributes to better judges, and so actual independence, in the sense that candidates who know what the process is are potential candidates will be more motivated to apply when they have that transparency. This is the opposite of older systems where it's not transparent, it's closed, and there's often an understanding among potential candidates that only those with connections to the powerful and who are therefore part of those networks will succeed, so there's no point in applying. This transparency, I think, really improves actual independence as well. Now, if we look at the courts in Latin America, we find that the highest courts, again, are treated differently from the lowest courts. So appointments are not here, with one or two exceptions, in the hands of an independent body like a judicial council. They do have the political branches, the executive and the legislature involved. However, it's usually two or more of those branches, or two or more subsets of those branches, and they tend to work together with one, commonly the president, producing a nominee or a list of candidates, and then the other, most commonly a chamber of the legislature, voting whether to confirm that candidate or choosing from the list. Further safeguards exist in some places, for example, 2/3 requirement for confirmation, or the screening of candidates by judicial councils, or a nominating commission specially formed for those highest court appointments. Now, as with any safeguard, one has to examine exactly what is the system and the composition of that safeguarding body. And in our research, we came across some interesting examples. So Guatemala, for instance, has a nominating commission. Academics, one representing each law school, make up 1/3 of that commission. But what seems to have happened, according to reports we read, is that fake law schools, or law schools without any students yet, have been established to give those seats to usually powerful political groups that want to influence the process. So one has to look at these things very carefully. And finally, transparency plays an important part in making appointments work. So there are several examples of transparency in the highest court appointments that discussed in our report. I want to highlight Argentina. The other two examples are Colombia and Peru. In Argentina, the 2/3 threshold was introduced in 1994, and about a decade later, it was also required for the president to publish the name of his or her nominee, and then to allow a certain period where civil society could scrutinize them, and that they would also have access to the nominee's record as a lawyer, their clients, any potential conflicts of interest. And that, commentators agree, has improved both public awareness of the candidates, but also the independence of the Supreme Court. So much so that the last two appointments, the government tried to avoid the process by making recess appointments. And I want to then, because time is running short, mention the position in the lower courts as well. So here, Latin America has the civil law tradition of the career judiciary to fall back on. And as we heard from Ministro Mendes yesterday, the practice of open competition of examinations to select judges. So there's a very valuable starting point there. And increasingly, the bodies responsible are now judicial councils rather than in the past the Supreme Court choosing judges. However, there are problems. Sometimes the composition of the council goes in the direction of being heavy with politicians. Argentina has seen that with its federal judicial council. And I think this is a distraction from the work that has always been done in selecting judges, which is to assess them. So through these examinations, for instance, and that has to be done against criteria. Now, I want to end on that general note. I know that Julio has comments prepared on the lower courts by saying that in our Cape Town principles, which are available in Spanish and Portuguese among the materials, we do deal with the question of how candidates should be assessed. The key principle is that what you ask candidates to provide, what you ask them in an interview, must be relevant to the criteria, to the qualities that make a good judge, so that it all becomes more objective as an assessment of their quality. And I mentioned we have materials. Well, these are just to summarize, the report is available in English. There's summaries in Spanish and Portuguese, and it will be online as well. And thanks to Arias and Munoz also for the production of this report. Thank you.
Gracias. No. Gracias. I'm going to switch to Spanish. Muchas gracias a los organizadores de esta interesante conferencia por la invitación. Ha sido el día de ayer muy interesante en temas que tienen que ver con el Poder Judicial y su función de rendición de cuentas en las democracias latinoamericanas. Me pidieron comentar el excelente reporte de Jan sobre la independencia judicial en la región. Debo decir desde el inicio que me ha dado muchísimo gusto leerlo, está muy bien documentado, tiene todos estos elementos teóricos y también un análisis de casos recientes. Ha habido mucha actividad en este tema en los distintos países latinoamericanos. Jan, como vimos, documenta la interesante variación que existe en estos rubros de la duración de los jueces en su cargo y el proceso de nombramiento en los distintos países de la región latinoamericana. Lo que voy a hacer en estos comentarios es enfatizar algunos de los temas que están presentes en el reporte de Jan y abrir algunas preguntas tratando de propiciar el debate. El primer punto que quiero hacer es que, desde mi punto de vista, el reporte de Jan deja claro que en términos del diseño institucional, del nombramiento de jueces y de la duración en su cargo, es muy claro lo que está mal, pero no sabemos cuál es el modelo correcto. O quizá no hay un modelo correcto para ponerlo en términos diferentes. Si pensamos en el objetivo de promover la independencia de los jueces de las altas cortes constitucionales o supremas respecto de los poderes electos, ¿no?, ejecutivo y legislativo, que es el objetivo tradicional, entonces hay claros ejemplos de un mal diseño institucional, ¿no? Nicaragua, Perú y Guatemala eligen a los jueces supremos o constitucionales o por 5 años. Eso está claramente mal, ¿no? Duran el mismo tiempo que los legisladores, el mismo tiempo que el ejecutivo, la posibilidad de influencia, cualquier persona, o sea, no importa quién sea, los jueces herculeanos de Ronald Dworkin o quien sea, va a sentir la presión del contexto político. En el proceso de nombramiento también hay unos claros ejemplos de lo que está mal, de lo que se debe evitar. Aquí Perú a mí me parece un caso claro de algo que está mal, dado que es un órgano nada más, el Congreso de la República, con una votación supermayoritaria, pero solo un órgano el que decide el nombramiento. Y hay otros casos, como recientemente la República Dominicana, en donde es solo el Consejo de la Judicatura, politizado, que nombra a todos los jueces del país. Aquí el punto sería, cuando dejamos en manos de un solo órgano, sin alguna posibilidad de contrapeso por parte de otro que tenga intereses distintos, entonces puede haber, digamos, nombramientos sesgados. Respecto a los jueces inferiores y su independencia o la independencia que se busca de promover respecto a sus superiores y respecto a quien administra la carrera judicial en general, también hay claros ejemplos de lo que deberíamos de evitar. Uno son lo que mencionó Jan, los nombramientos temporales y peor aquellos hechos por el Ejecutivo, ¿no? Hay muchos lugares como Venezuela o Perú, como menciona Jan en el reporte, en donde un gran número de jueces son nombrados, son temporales, pero duran tanto que parece que son jueces ya normales, y estos son nombrados por el Ejecutivo directamente. En cuanto al ingreso y la promoción, el ascenso en la carrera judicial, también cuando los jueces son nombrados bajo la influencia directa de la Suprema Corte o del órgano encargado de la carrera judicial, como en Chile o Costa Rica o México, pues algo no está bien. O sea, debería de haber una independencia de aquellos que nombran o del proceso de selección, de las que controlan el proceso de selección. Pero el punto es, más allá de estos ejemplos en donde sabemos lo que hay que evitar, ¿cuál es el diseño correcto? Yo creo que, no sé si es que no sabemos o no hay, no sé si hay un diseño óptimo, ¿no?, para obtener la deseada independencia de facto o la independencia real, como decía Jan. Respecto a la duración en el cargo, por ejemplo, ¿por qué no los 9 años que duran los jueces constitucionales en Colombia o más aún los 15 años que duran en México? Porque esto no es suficiente para producir los objetivos de estabilidad y largos horizontes. Hay debate sobre el tema, lo reconozco, y aquí Jan parece inclinarse por los nombramientos vitalicios, igual que la comunidad internacional, pero a mí no me queda todavía claro por qué los nombramientos vitalicios son lo mejor. De hecho, hasta hay argumentos en donde si el salario es muy alto y duran mucho tiempo los jueces, y por otro lado es fácil removerlos, que es otro de los temas que se discutirá después, los jueces tenderán a ser más deferentes con el poder político en lugar de más independientes, porque es tan valioso lo que tienen que no lo van a querer perder, ¿no? Eso fue lo que hizo Lee Kuan Yew en Singapur. No quiero decir de México, pero igual ganan muchísimo los jueces y son muy, muy deferentes con el poder político. No sé si exactamente por esta razón, pero digamos, al menos está el argumento. Respecto al proceso de nombramiento, siempre y cuando se eviten los diseños que son claramente perversos o que generan incentivos perversos en los jueces, yo creo que hay diversos diseños que pueden igualmente servir el objetivo de promover que lleguen buenos y capaces, honestos y, digamos, hábiles jueces que decidan libres de presiones indebidas. Un tema que creo que sí es importante para todos los tipos de nombramientos, y es algo que Jan enfatizó, es lo de la transparencia. La transparencia en la selección de candidatos, la justificación pública del nombrador de por qué esta persona es la adecuada para el cargo, y la participación activa de la ciudadanía o la opinión pública. Hemos visto que cuando esto ocurre, como en Argentina, que mencionó Jan, no siempre lo hacen, pero cuando lo hicieron hubo resultados positivos. En Colombia también recientemente el presidente Santos fue ejemplar en la propuesta de la terna, y en cambio los lugares en donde esto no ocurre, con distintos tipos de nombramientos, pero cuando se hace en secreto o rapidísimo, de tal modo que no da tiempo ni siquiera de discutir quiénes son y si el perfil del juez es adecuado, como México o Perú, hay resultados indeseables en términos de quién queda electo. Entonces, yo creo que hay una diferencia, hay varias respuestas acerca de qué es lo correcto, y si hay algún elemento que creo que puede servir en general es este de la transparencia, que, dicho sea de paso, en ningún país está institucionalizado, ¿no? De modo que siempre se haga de algún modo, ¿no? Se han intentado en algunos lugares hacerlo de un modo u otro, sacando los nombres en el periódico, dando un periodo de tiempo, pero después en la siguiente nominación se cambian las reglas, no es algo que esté claramente establecido. El hecho de que existe la variación institucional en la región en estos temas de nombramiento y duración es claro. La pregunta relevante es, ¿y hace alguna diferencia o no? Eso es lo que nos importa, ¿cierto? O sea, lo que queremos es jueces que de facto decidan de manera independiente. Entonces, el segundo comentario que quiero hacer tiene que ver con esta pregunta de los efectos de las distintas instituciones. Ayer el presidente Mesa decía, es un tema cultural y la cultura apareció en varias de las presentaciones. Y por otro lado, Kevin Casas decía, no es un tema cultural, es un tema de instituciones. Con las instituciones correctas se pueden producir cambios rápidos, ¿no? Entonces la cosa es, ¿estas variaciones en nombramiento y duración tienen efectos o no? Es una pregunta muy difícil de responder. Lo que quiero señalar acá es que podemos ir a las causas de la variación para tratar después de entender un poco los efectos de los distintos tipos de nombramientos. Y para hablar de estas causas voy a referirme a la independencia interna o a los nombramientos y duración de jueces en otras cortes, que esta es una virtud del reporte de Jan, que no se centra en las altas cortes, sobre las que sabemos relativamente, digamos, no todo lo que queremos, pero se sabe bastante más en la región de lo que sabemos respecto a los otros jueces y las otras cortes. Entonces, el punto es, ¿contra quién o contra qué se diseña un mecanismo de nombramiento y cuál es el mecanismo por el cual se adopta una nueva constitución o una reforma constitucional? Creo que estos dos elementos de contra qué se hace, y enfatizo el contra, y cómo se implementa o cómo nace estos sistemas de nombramiento, puede tener un efecto en las consecuencias. Es muy importante esto porque es el fortalecimiento del poder judicial en general y no solo de las altas cortes, es lo que va a permitir a esta institución, digamos, convertirse en un poder que pueda realmente contrapesar a los otros y al mismo tiempo funcionar de manera eficiente. Bueno, como decía Jan, en la selección de estos otros jueces de las cortes ordinarias e inferiores, participan los consejos de la judicatura, magistratura, Judicial Councils, ¿no? Tienen varios nombres. Aquí es importante mencionar que mientras que en Europa, en los países de la Europa continental, España, Francia, Alemania, los consejos de España, Francia, Italia, los consejos de la judicatura nacieron para aumentar la independencia de los jueces respecto del poder ejecutivo, dado que la carrera, los nombramientos se controlaban estaban en el Ministerio de Justicia. En América Latina, los consejos nacieron para aumentar la independencia de los jueces respecto a sus superiores en el Poder Judicial, o sea, las Cortes Supremas, que eran las que controlaban el ingreso, la selección y los controles disciplinarios de los jueces. Este control por parte de las Cortes Supremas generó, de la carrera judicial, generó en muchos lugares regímenes clientelares donde los méritos profesionales y las capacidades intelectuales eran menos importantes que las conexiones familiares o de otro tipo con algunas figuras políticas o con los magistrados de las Cortes Supremas. En México, por ejemplo, durante más de 70 años, la Corte Suprema controló a discreción el nombramiento y promoción de jueces mediante lo que ellos llamaban un pacto entre caballeros, ellos los ministros de la Suprema Corte, que consistía básicamente en tomar turnos para nombrar gente cada vez que había una vacante, y el segundo elemento del pacto era que todos los ministros votaban unánimemente a favor del nombramiento, sin revisar absolutamente nada, sabiendo que cuando a ti te tocara nombrar a alguien, iba a haber un voto unánime también. Se fue gestando esta institución informal del pacto entre caballeros. En los primeros años después de la Constitución de 1917 se estableció hasta 1994. El nivel de clientelismo y corrupción que generó hacia el final este sistema llegó a niveles bastante altos, y justo en 1994 se crea un Consejo de la Judicatura para tratar de romper estas redes clientelares y promover la meritocracia en la selección y promoción de los jueces. El punto es que el diseño de los mecanismos de nombramiento y duración, en este caso de jueces inferiores, tiene en parte que ver con qué es lo que se busca combatir. En muchos países, los consejos de la judicatura se crearon al inicio de la transición democrática y depende de qué ocurrió antes, ya sea en el periodo autoritario o en el periodo democrático anterior, para ver exactamente por qué y cómo se diseñó el sistema de nombramiento o la composición del Consejo de la Magistratura de una cierta forma. En algunos casos, como Brasil, ayer nos recordaba el ministro Méndez, el Consejo de la Judicatura se creó relativamente tarde, 2004, en parte porque había una norma preexistente de profesionalismo con problemas y cierta independencia del cuerpo judicial. Entonces, la norma preexistente acá era positiva, el Consejo de la Judicatura viene a complementar, digamos, a arreglar lo que existía. En otros lugares, la norma preexistente era clientelar y el Consejo de la Judicatura trata de arreglar. Obviamente, qué tan efectivo es un consejo depende de cuál es la norma preexistente. En México, yo les puedo decir, ya no estamos en la situación pre-94, pero la Suprema Corte de Justicia no ha querido sacar las manos de ese verdadero poder, como me dijo a mí una vez un ex juez de la Suprema Corte de Justicia y ex consejero de la Judicatura. El verdadero poder no es el poder de revisión constitucional, es el poder de nombrar. Nombraban hasta 1994 hasta niñeras, choferes, tenían un poder administrativo y obviamente de control de presupuesto enorme, que es lo que vino a romper el Consejo de la Judicatura en 94. Pero la Corte ha encontrado modos de interferir, de intervenir, de influir el Consejo de la Judicatura de 1994 para acá, esto en México. Y en parte por la segunda razón que mencionaba antes. El Consejo de la Judicatura en México, al igual que el brasileño, se creó en una reforma constitucional, no en una nueva constitución, ¿no? Y cuando se hace una nueva constitución hay ventajas, ¿no? Como en Colombia, como en Bolivia. No solamente se creó el Consejo de la Judicatura en 1991 en Colombia o 95 en Bolivia, se rediseña todo el sistema de justicia, ¿no? Como en Brasil en el 88, pero ahí no se creó el Consejo. No, se rediseña todo, la Fiscalía, la Corte Suprema, se crea la Constitucional. Hay muchos elementos que están cambiando. Cuando se hace una reforma, en cambio, se cambia solo una pequeña parte y la inercia del resto de las instituciones afecta el desempeño de aquella pequeña parte que se cambió. No solo eso, cuando se hace una reforma constitucional, los órganos a los que se les quita poder mediante la reforma, en el caso que conté, la Suprema Corte de México mediante la creación del Consejo de la Judicatura, pero eso es igual en varios lados, los órganos que pierden poder tratan de defenderse y por lo tanto alteran desde el diseño del Consejo hasta el funcionamiento posterior a la creación del órgano. Dicho sea de paso, y con esto termino, los tribunales constitucionales que Jan mencionaba, que hay solamente 8 en la región, todos se crearon en una nueva constitución. No se ha creado jamás en América Latina un tribunal constitucional, estilo del Supremo Tribunal Federal, por reforma constitucional. Ahí se defienden mucho las Cortes Supremas. En suma, y para concluir, creo que dado que lo que nos importa es la independencia judicial de facto y hay distintos elementos institucionales que afectan esto, lo importante es evitar los diseños que son claramente malos y tratar de entender las causas de la variación en los distintos diseños de nombramiento y duración para ver si es que hay algún óptimo en términos de qué produce mejores resultados en los distintos países. Muchas gracias.
Thank you. So, thank you very much for the presentation. In this talk, I will be presenting a paper as was said, that I wrote for the International Bar Association's Human Rights Institute on judicial independence and accountability in the region. And thank you very much to the Bingham Center and the organizers of this conference for the opportunity to launch this report here at this conference. It's a pleasure to be here. We have just heard from Dr. Van Zyl-Smit about the appointment and tenure of judges in the region. The focus on the IBA paper, this paper that I'm presenting instead, is on the accountability and, in particular, the ways in which judges are disciplined and removed from their posts. In Latin America, there are ongoing concerns of governments attempting and sometimes succeeding to exert control over disciplinary proceedings, and also there are concerns of governments otherwise exerting control over judiciary by intimidating judges or forcing resignations. There are emblematic cases, such as the case of Judge Afuini in Venezuela, which drew international attention to this problem. And there are also frequent and questionable removals of judges in other countries, such as, for example, in Ecuador, Honduras, and several other countries as well. These examples clearly demonstrate the scale of the problem. The International Bar Association's Human Rights Institute has carried out a lot of work on the rule of law and on the independence of the legal profession in various individual countries in this region. Last year, we noticed that in many countries across the region, there were similar issues which were arising with regard to judicial disciplinary procedures, and therefore, instead of focusing on and issuing a report on one particular country, for example, Argentina or Bolivia, the IBA decided to commission a thematic paper to highlight the trends that can be seen across the region in issues concerning the discipline of judges. The purpose of this paper, therefore, was to look at disciplinary proceedings in the region, who is in charge of them, when and how can judges be disciplined, and whether or not these proceedings are affected by politicization and informal interferences in practice. The name of our paper, A Double-Edged Sword, springs from the dilemma that whilst accountability is absolutely necessary, it can be harmful to judicial independence when disciplinary mechanisms are abused so as to exert control over the judiciary. However, the reference to a double-edged sword is also an encouragement to view accountability as a tool that, when properly implemented, cuts both ways and would root out both corruption and nepotism in the judiciary, but also would catch any undue influence by the executive on the judiciary. The report makes 4 clear recommendations that I'll summarize briefly here. The report also identifies areas that could be the focus of further research and further efforts to strengthen judicial disciplinary proceedings to ensure better accountability and independence in the region. We would be very interested in hearing your views on this, and I look forward to hearing your comments on some of the recommendations after this talk. There have in recent years been many calls by governments throughout the region to make judiciaries more accountable. Indeed, we heard from Justice Mendes yesterday that this, to a certain extent, is both necessary and desirable. Several governments claim that the judiciary is out of touch with ordinary citizens, and some of these criticisms have gone as far as to portray judiciaries as self-interested corporations that hold onto political power without being democratically accountable for their decisions. In some places, this has even led, in some countries in the region, this has even led to calls for democratization of the judiciary. Whilst that term appears to be conceptually problematic and indeed it is unclear exactly what it means, these concerns do appear to reflect public perception of the judiciary in the sense that, from the data that is currently available, there is a severe lack of public trust in the judiciaries of the region, and this is obviously a major concern for the respect of the rule of law in the region. According to the World Justice Project's 2015 Rule of Law Index, the Latin American and Caribbean region scores an average of 0.48 for the absence of corruption in the judiciary. This is on a range from 0 to 1, with 1 being the best possible score. Other indices all tell the same story. All studies show that a majority of respondents feel that the judiciary is corrupt. It is important to note here that there is, however, a lack of detailed data on public perceptions of the judiciary, and the current data does not tell us why participants consider the judiciary to be corrupt, nor exactly how they consider it to be corrupt. For example, to give you an example of the different interpretations that could be made of the current data, the public's perception of how the judiciary is corrupt could be because of 2 reasons. It could be that they view the judiciary as acting in a self-interested way, in a corporatist way, or they could perceive the judiciary to be subservient to the government. There is a very important difference between the two. It is equally unclear why the government why respondents perceive the judiciary in this way. Is it from personal experience or because of public and media discourse? More detailed research on this area would be very welcomed, not least because it would serve to examine whether or not public perceptions match the concerns which are voiced by governments in the region. The fear, however, of course, is that governments' calls for accountability of judiciaries and attempted reforms are simply ways to gain power over the judiciary and undermine judicial independence. It is important to point out here that it is clear that the majority of countries in the region are bound by their national constitutions and international law to protect judicial independence. And with regard to disciplining judges, international and inter-American bodies have also clearly stated on several occasions that protecting judicial independence includes ensuring that judges can only be removed in accordance with fair, objective, and impartial procedures, and that judges should not be removed for decisions taken in the exercise of their function. Whilst these overarching principles are clear, the procedures for disciplining judges and removing judges across Latin America varies very widely. On one end of the spectrum, there are jurisdictions where judicial discipline is internal to the judiciary, and on the other end of the spectrum, there are jurisdictions where the discipline of judges is conducted exclusively by the legislative branch. Several countries across the region have also formed judicial councils, as we've heard before, or impeachment juries that are in charge of judicial discipline. But their compositions vary very widely across the region, and in some cases, such councils are part of the judicial branch, whereas in other countries there's a hybrid system, and in other countries the Judicial Council is technically speaking independent. In many jurisdictions, there is also an increasing emphasis on civil society involvement in the proceedings for disciplining judges, but civil society generally only has a small representation in such proceedings, and there are several problems associated with this in practice. The question as to who has the power to discipline and remove judges has been very controversial, and it has resulted in frequent changes and criticisms of judicial disciplinary bodies across the region. It appears, however, that much of this controversy is fueled by a mistrust of motives. There is a fear that whoever does gain a seat at the table may try to influence disciplinary proceedings to work in their favor. The real focus, therefore, should be actually on why and how people are able to exert undue pressure on disciplinary proceedings in practice, and the focus should be on making changes not in order to change the balance of influence in judicial councils, but rather to ensure that no one is able to unduly influence these proceedings at all. There is a need for more in-depth research to understand exactly how the disciplinary bodies are working in practice currently, and to identify when and how informality, politicization, and abuse of process affects these proceedings. A preliminary review of the situation across Latin America certainly does suggest that there is a trend of judicial disciplinary proceedings being affected by informality. These occurrences can broadly be categorized into two types. The first is where judges are investigated, disciplined, or removed through an official disciplinary proceeding conducted by a judicial council or another disciplinary body. In such cases, there are several concerns about informal interferences which result in a lack of due process of the proceedings. Concerns range from investigations being halted to processes being sped up, and of judges not being given an adequate chance to present a defense against the charges against them. The appearance of bias in proceedings is compounded by the fact that disciplinary bodies frequently fail to give explanations for their decisions. And there's research on this which demonstrates that this appears to be the case in countries such as Argentina, Peru, Bolivia, and several others. There are many issues to be addressed in order to resolve the problem of informality in disciplinary proceedings, but our report makes two recommendations in this regard. The first is there needs to be a clearer set of rules setting out the standards to which judges are held to, and to identify exactly what conduct warrants the removal of judges or other disciplinary sanctions. The second recommendation is that, as we said before, transparency is important. We recommend an improvement in the transparency of disciplinary proceedings, and in particular an obligation on disciplinary bodies to publish reasons for their decisions. The other type of interference that can be seen across the region in the discipline of judges is a more aggressive and direct form of interference. In these cases, the pressure is not exerted on disciplinary bodies, but directly on judges by way of discrediting them, intimidating them, or forcing resignations. Governments, for example, frequently in the region make statements discrediting the judiciary. And there are several cases of judges being intimidated and physically harmed. The seriousness of this issue cannot be understated, both due to the human rights abuses suffered by judges and due to the climate of fear that this creates in other judges. It creates a so-called Afuini effect. The International Bar Association interviewed many judges in Venezuela and noted in its report that they always hear the same thing: no one wants to be the next Afuini. In Venezuela, as throughout the region, and as Jan pointed out earlier, there is also a worrying trend to appoint provisional and temporary judges. And this can be seen in almost all countries across the region. And this is problematic in terms of removal, as it appears to be just another way of subverting the proper disciplinary channels. This interference is clearly detrimental to the rule of law generally, and judicial independence specifically, but it is also detrimental to judicial accountability. And that is just as important as the effects on judicial independence. Where disciplinary systems are not working properly, accountability is not working properly. It means that those judges that engage in corruption or bend to the will of the executive due to fear or favor are protected. They are not sanctioned. And of course, judges who demonstrate independence may also face removals when ruling independently on politically sensitive matters. This is detrimental to the proper working of justice, but will also result in a further lack of trust in all institutions, including the judiciary. And a malfunctioning judiciary exposes itself to further criticisms, attacks, and justifications for further reforms. Whilst it is therefore understandable that judiciaries are wary of government's motives, a resistance to change and a resistance to calls for accountability may simply fuel further criticism of judiciaries that are insular and unresponsive. The mistrust of motives is unhelpful. It detracts from the crucial debate that is needed about the nature and extent of judicial accountability and how the impartiality of disciplinary systems can be ensured. Accountability, when properly implemented, should be a well-defined, transparent, and impartial system that cuts both ways. Accountability should not be a threat to judicial independence, but rather a tool to strengthen it. And accountability should therefore be embraced by judiciaries as a way to promote the integrity of their institutions. If judiciaries across Latin America take the lead in promoting their own integrity and demonstrate a willingness to be held accountable for the proper and impartial exercise of their function, they may be able to answer government's calls for accountability and protect themselves against further attacks. There have been several encouraging advances across the region in terms of increase in transparency of judicial proceedings and the implementation of several judicial codes of conduct, but there is still a need for reforms to encompass courts at all levels. And also there is a need to better understand the corruption risks associated with the judiciary. An insistence by the judiciary to build impartial systems of accountability and a willingness to adhere to such systems would protect the judiciary from abuses, it would strengthen the rule of law in the region, and it would be also a very valuable contribution to the debate about the proper extent of judicial accountability. As we heard from Sir Geoffrey Jowell yesterday, the questions of accountability and independence resonate throughout the world, and the lessons from Latin America are very relevant to us all. Thank you.
Bom dia a todas e a todos. Bom, antes de tudo eu gostaria de agradecer por estar aqui comentando um paper, um report tão importante a respeito do tema da independência judicial e da accountability, especialmente por ser este um report que está sendo lançado hoje, né? Então agradeço pela leitura muito agradável que a Jéssica proporcionou. Bom, esse é um texto que, de alguma forma, começa com um título bastante sugestivo, né, e curioso, que mostra justamente essa relação tão imbricada entre a independência judicial e a accountability judicial. E, como a Jéssica diz no texto, trata-se de uma relação que tem uma faca de dois gumes, ou seja, é uma relação ao mesmo tempo perigosa, né, mas que pode dar certo, né, a depender dos cuidados que a gente tomar. E eu vejo como uma das principais contribuições desse paper é justamente as reflexões relacionadas à pergunta que eu acho que é a pergunta central das discussões que a gente tem tido aqui desde ontem, né, que é justamente como proteger a independência judicial e, ao mesmo tempo, fortalecer os mecanismos de accountability. Ou seja, como manejar adequadamente essa faca de dois gumes para que ninguém se corte, né? Acho que é um pouco exatamente esse o argumento central do texto. E, justamente, são apresentados alguns indícios e algumas recomendações, né, para responder essas perguntas. E eu gostaria de retomar aqui o principal argumento que eu acho que a Jessica trouxe, que é justamente o fato de que a accountability, ou seja, o controle, a responsividade do judiciário, não deve ser uma ameaça à independência judicial, mas sim um mecanismo de fortalecer essa independência judicial. Então, acho que essa é a ideia central do texto. Bom, e eu estou aqui na posição de comentadora, portanto, eu vou tentar ser breve para justamente abrir a oportunidade da plateia também poder comentar trabalhos tão importantes e interessantes nessa manhã. E eu queria, os meus comentários, na verdade, serão para ressaltar 3 aspectos, e são aspectos que, de alguma forma, eu poderia contribuir com o aprimoramento de algumas ideias e para que a gente também possa aqui debater. Em primeiro lugar, eu gostaria muito de ressaltar a relação e, na verdade, a importância da relação da independência judicial e da confiança no judiciário, que é colocado, muito bem colocado, no report. E aí a autora cita tanto o Latino Barômetro quanto o Rule of Law Index. Eu concordo muito com essa relação, né, entre a independência judicial e a confiança no judiciário, e em que medida isso afeta o desempenho do Estado de Direito, do Rule of Law. Então, de fato, uma das questões que afeta profundamente o desenvolvimento econômico e social de um país é justamente a capacidade do judiciário, ou do sistema de justiça, se colocar como uma instância legítima para resolver conflitos que surgem no ambiente social, no ambiente empresarial, no ambiente econômico, enfim. E uma das formas, justamente, de se medir essa legitimidade do judiciário é através das motivações que, de alguma forma, levam os cidadãos a buscar o judiciário para solucionar conflitos, e também no modo como as pessoas confiam ou não no judiciário. Isso em termos de eficiência, né, de celeridade na resposta judicial, ou em termos de independência, justamente pensando aí na ausência de influência nas decisões por parte de poderes políticos, né, os outros poderes, e também em termos de acesso, em termos de honestidade, em termos de imparcialidade. Tá? E aqui no Brasil, vocês devem ter ouvido falar isso ontem, especialmente na fala do ministro Gilmar Mendes, que o Brasil teve uma crise, né, no sistema judiciário desde a década de 80, e isso é um ponto em comum com os outros países da América Latina, né? E uma das discussões que começou lá em 1992, com a proposta de reforma do judiciário do Hélio Bicudo, como também mencionado pelo ministro Gilmar Mendes, suscitou diversos questionamentos a respeito de qual deveria ser o objetivo dessa reforma do judiciário. Deveríamos democratizar o acesso à justiça ou deveríamos priorizar a racionalização dos instrumentos judiciais, ou seja, promover maior celeridade? E isso despertou diversas discussões, né, dentro do cenário legislativo e também dentro da academia e dos grupos de magistrados, que questionavam aqueles mecanismos de concentração de poderes nas cortes superiores, de forma a agilizar a resposta das instâncias inferiores. Então, o principal argumento, justamente dos magistrados de primeira e segunda instância, foi que esses mecanismos de concentração de poder nas instâncias superiores feriria a independência judicial. Então, essa foi uma grande marca, uma característica muito importante da reforma do judiciário. O que mais a reforma do judiciário trouxe? Né? Então, a partir de 2004, com essa reforma, tivemos aí a implantação, como bem lembrou o Figueroa, que foi criado o Conselho Nacional de Justiça. Né? Então, aqueles conselhos judiciais, o conselho nosso aqui no Brasil, foi criado por uma reforma constitucional. E, a partir da criação do Conselho Nacional de Justiça, nós tivemos maior produção e disponibilização de dados a respeito do judiciário, ou seja, número de juízes, número de varas, quantidade de casos novos que chegavam. Isso, de alguma forma, facilitou, fez com que nós compreendêssemos melhor como que era esse diagnóstico de crise do judiciário. Tá? Porém, apesar dos avanços na publicação de dados, e aí estou falando um pouco mesmo da ideia de transparência, né? Como é que a gente enxerga a estrutura do Poder Judiciário por meio de dados, né? Então, apesar desses avanços na produção de algumas informações, nenhuma desses dados mostra questões objetivas sobre a forma pela qual o Judiciário, de fato, aparece como uma instituição confiável em termos de eficiência, imparcialidade, honestidade e independência. E essas informações, que são coletadas a partir de informações produzidas pelos próprios tribunais, também não oferecem indícios que mostram por que é que as pessoas vão até o judiciário. Tá? Então, na tentativa de suprir essa deficiência na produção de dados aqui no Brasil, a FGV Direito de São Paulo criou 2 indicadores, ou 2 índices, para retratar justamente a relação entre o indivíduo e o Estado de Direito. Eu vou falar rapidamente dos 2. O primeiro deles, que é o que mais importa aqui, é o Índice de Confiança na Justiça, né, que busca retratar a confiança da população no judiciário, no sistema de justiça. E o segundo índice, que é o Índice de Percepção do Cumprimento da Lei, procura justamente retratar a percepção dos brasileiros com relação ao respeito que as pessoas têm à lei e também às ordens de algumas autoridades. Esses índices mostram e estão muito em consonância com os indicadores que a própria Jéssica trouxe, é que a maioria das pessoas, aqui no Brasil, a maioria significa aproximadamente 70% das pessoas têm pouca ou nenhuma confiança no judiciário. E esse dado reflete a percepção que as pessoas têm no que diz respeito à independência judicial. Ou seja, também a maioria das pessoas acredita que o judiciário não é independente. Ou seja, que o judiciário é influenciado por outros poderes políticos. Tá? Então, essa percepção e essa relação entre independência judicial e confiança na justiça como instância legítima para solucionar problemas de uma sociedade é, de fato, muito importante, justamente para também nos motivar a procurar quais são as falhas, portanto, desse sistema judicial e o que podemos fazer para melhorá-lo, né? E achei importante, na verdade, trazer esses indicadores, porque foi justamente esse, acho que, um ponto comum que fez com que o Bingham Center se juntasse aí à FGV, para que a gente pudesse discutir e, querendo ou não, colocar de pé esse evento. Então, por isso eu não poderia deixar de mencioná-los. Bom, esse foi o primeiro ponto, o primeiro aspecto que eu gostaria de destacar. O segundo ponto é justamente trabalhar com o tema dos conselhos judiciais, né? Bom, uma das propostas colocada no report para preservar a independência judicial e fortalecer a accountability é a necessidade de ter processos disciplinares judiciais que sejam transparentes e imparciais, né? E chama-se muita atenção para o fato de que, para que isso aconteça, precisamos ter clareza na definição do que seria uma boa ou uma má conduta, né, dos juízes, para que essa sistemática dos procedimentos disciplinares aconteça de forma independente e imparcial. E aí, uma das sugestões do texto é justamente colocar aí, abrir uma agenda de pesquisa, né, para que se investiguem como que são exercidos esses poderes dos conselhos judiciais, que no caso do Brasil é o Conselho Judicial, é o Conselho Nacional de Justiça, que tem a prerrogativa ou a competência justamente de avaliar a conduta dos juízes em processos disciplinares, né? Para além, claro, dos órgãos que existem dentro dos próprios tribunais. mas o Conselho Nacional de Justiça exerce um papel muito importante aí. E aí, existem alguns estudos aqui no Brasil, muito recentes, na verdade, que se debruçaram sobre a análise desses procedimentos disciplinares. Um deles é uma tese de doutorado de um colega, o Diogo Reis, justamente sobre a atuação do CNJ em independência judicial, que é também justamente o tema da palestra de ontem do ministro Gilmar Mendes. Mas eu queria, talvez, complementar, a palestra de ontem, justamente trazendo alguns dados empíricos que foram examinados nessa pesquisa, que olhou para mais de 2.000 procedimentos disciplinares do CNJ. E viu-se que o CNJ ele decidiu, em apenas 3 casos, suspender as decisões dos juízes investigados. E, em outros 80 casos, dos 2.750 analisados, o CNJ decidiu por manter a decisão, mas puniu o juiz, com a pena de advertência ou suspensão ou até mesmo aposentadoria compulsória. Então, vejam que é interessante de ver que os conselhos judiciais, talvez por serem muito recentes, ainda têm uma atuação tímida com relação aos procedimentos disciplinares. Então, esse é apenas um indício, eu acredito que, como a Jéssica coloca no seu texto, é uma agenda importantíssima que a gente precisa começar a enfrentar aqui no Brasil. Essa ideia da independência judicial e como é que os conselhos judiciais exercem esses procedimentos disciplinares. Por fim, o meu último comentário diz respeito a uma das recomendações finais que é feita no texto para fortalecer a accountability judicial. E uma dessas recomendações diz respeito ao aumento da transparência no judiciário, especialmente por meio da disponibilização de decisões e por meio da disponibilização das razões que levam o juiz a tomar determinada decisão. E mais, uma das sugestões também seria, por exemplo, televisionar as sessões de um tribunal. É interessante de ver que, no Brasil, de alguma forma, nós temos esses mecanismos. Então, todas as decisões que não são do seio de um processo sigiloso estão disponíveis para todo mundo acessar, qualquer pessoa. E mais, vocês devem ter visto que as sessões do Supremo Tribunal Federal, como mencionado ontem também pelo ministro Gilmar Mendes, são televisionadas, ao vivo, o tempo inteiro, durante 24 horas. Desculpe. Mas aí eu me pergunto, será que isso de fato é transparência? Por que eu pergunto isso? Porque eu acho importante a gente discutir pelo menos o conceito de transparência e ver em que medida isso pode de fato acontecer para que possamos fortalecer a accountability. Por que eu digo isso? Porque, por exemplo, a partir da instalação da TV Justiça, que é quem televisiona todas as sessões de julgamento do Supremo Tribunal Federal, viu-se que muitas das decisões têm aumentado de tamanho. Então, elas passaram de 100 páginas para 300, 400 páginas. E aí, esse tipo de aumento acaba dificultando muito mais do que facilitando a disponibilização ou a transparência. E mais, algumas vezes, muitos dos ministros veem ali que estão sendo televisionados e o que acaba acontecendo? Cada um tem a sua posição e, chega no final, nós não conseguimos saber de fato qual é a decisão do tribunal. Então, acho que uma principal questão aqui para que a gente possa pensar é o que significa transparência e como fazer para, de fato, implementar um judiciário transparente. Bom, por fim, agradeço mais uma vez pela oportunidade de ler o seu texto, Jéssica, e agradeço a todos pela atenção. Obrigada.
My thanks to all of those presenters. There is a wealth of expertise quite clearly amongst that group. In terms of time, we are quite pressed. What I think I might do is open this to the floor for some questions. Whether we get time to answer some of those questions might be a different matter, but I think to get some of the views from the floor would be good. Does anybody want to start? Am I able to see? Yep. One there.
I'm going to switch to English. So good morning. I was thinking about exactly what Luciana mentioned, the publicity of the decisions and the broadcasting of the sessions of the Supreme Court in Brazil. Jessica mentioned about accountability, and Julio mentioned also formation and creation of the body of judges, and this is all meant to provide for more independence of the judiciary and the check and balances that we need to have in a democracy. But I would like to have a comment from Jessica and from Julio, and maybe the others if they feel comfortable with, on what's the efficiency of the publicity and broadcasting of these sessions. People tend to be at their best, as you say, when there's other people watching. So although, of course, there's lots of discussions outside of out of the cameras and recordings, of course, that when it comes to be viewed by others and broadcasted, and especially in our times when we have internet and technology very high and accessible to every person on earth, how efficient would this additional control be with respect to the independence of the judges?
Just in making those response, I might just take another question from the floor. Did somebody have a... Thanks, Tom.
Bom dia, gostaria de parabenizá-los pelas explanações. Eu sou advogado em Florianópolis. Uma pergunta mais relacionada com essa forma de escolher os juízes dos tribunais superiores. Aqui no Brasil, como nos Estados Unidos, grande parte do mundo, a escolha é feita pelo Executivo e depois é sabatinado pelo Legislativo. Eu sempre fui muito cético em relação a isso, justamente pela independência judicial. Mas, agora, recentemente, com a morte do Justice Scalia nos Estados Unidos, de lá fica bem claro, porque tem uma diferença muito grande entre liberais e conservadores, eu vi uma vantagem nesse sistema, justamente pelo fato de a escolha pelo presidente de um juiz de uma corte superior, no caso da Suprema Corte, ela vira um plano de Estado e não só de governo, porque aquele juiz vai ficar bastante tempo, até a aposentadoria, até a morte, e vai trazer para a corte valores que o próprio presidente tem para si. Ou seja, o presidente Obama ele vai escolher um juiz mais liberal, provavelmente, para a Suprema Corte, justamente para que, nesse tempo que ele fique lá, esse juiz interprete a Constituição de uma forma mais liberal, várias questões sociais, como casamento homossexual e coisas relacionadas. Então, eu gostaria de saber se isso é uma vantagem para essa forma de se escolher o juiz da Suprema Corte, e qual é a melhor forma, se não for essa, do Brasil e dos Estados Unidos. Qual é a melhor forma para se ter um juiz independente? Se existe uma forma melhor do que essa, como é que funciona aqui? Obrigado.
There's certainly one more question over here, and one there. We'll just take these two questions, then there's a lot of questions. What we might do is take these two, and then just time is beating us, so we'll take these and I'll address those. Thanks.
Okay, I'm Jose Antonio Munoz from Costa Rica with the Pan-Central American law firm of Arias y Munoz, and my question is, there was made a distinction about recognition, judicial appointments for the higher courts, and then the lower courts judiciary appointments. And I'd like to get some feedback from the panel on pros and cons of either approach.
Thank you. And just one more question.
Bom dia. Eu gostaria de saber a opinião dos senhores acerca das propostas que tratam de eleições diretas por juízes para as indicações para o Supremo Tribunal Federal e também para os cargos de presidente e vice-presidente dos tribunais estaduais. Obrigado.
Thank you. I think time, we are right, we're just a shade after 10:30 now. What I might do is, let's go till 10:36, which relies on a minute for each of our presenters for anything they might like to address that's come out of those comments, if you've got anything in closing. Who would like to start?
Bom, eu vou começar, acho que, pela questão a respeito da indicação dos ministros, né, para as Supremas Cortes, porque, com relação ao que ela perguntou, eu já falei. Então, eu gostaria de mencionar que, talvez, como disse o Figueiredo, não existe um modelo melhor, né? Eu acho que o modelo que temos aqui, de alguma forma, nós pudemos ver nos últimos tempos, especialmente no julgamento do Mensalão, né, um caso grande de corrupção que tivemos aqui, que parece que houve uma independência judicial, porque, embora aquela corte tenha sido majoritariamente indicada pelo próprio governo, foi justamente o governo que estava sendo réu naquela ação, e muitos, ou pelo menos alguns, articuladores importantes do governo ali foram punidos. Então, eu acho que esse foi um bom teste para a nossa Suprema Corte, verificar um pouco da sua independência judicial. Então, eu acredito que tenha sido um bom exemplo de independência, embora tenhamos essa questão de ser indicado pelo Executivo e depois sabatinado ou autorizado ali pelo Legislativo. Então, a minha opinião é que talvez possamos manter esse modelo, porque eu acho que ele demonstrou êxito nos últimos anos, a despeito de todas as circunstâncias que estamos vivendo hoje.
Thank you. I'd like to respond quickly to the question about the transparency. It's a very interesting question. I think that it definitely needs more consideration, but my initial feeling is that there is a clear distinction which has to be drawn between reform or between transparency on the one hand, and on the other hand, making the courts and the law more accessible to citizens. So if you have, for example, initiatives where you have the court proceedings being televised, this is perhaps more useful for the accessibility of the law and bringing citizens closer to the courts, to understanding the proceedings of the law. But that is perhaps the point of televising proceedings, is perhaps not to ensure transparency. Transparency is a separate matter. Transparency is simply a matter of judges providing adequate justifications for their decisions. So I think these are two separate matters and should be considered separately, but definitely the effect of one on the other should be considered further.
Those three quickly.
Yeah, a ver, solo un comentario respecto a la transmisión por televisión de las sesiones, que Brasil y México lo tienen. Yo comparto lo de Luciana. Me parece que está mal, que produce efectos indeseados en los jueces el que sepan que sus discusiones están siendo transmitidas en la televisión. Ojo, la deliberación es lo que creo que no se debe de transmitir por la televisión, que es lo que se transmite en México y Brasil. La audiencia, es decir, las dos partes frente a los jueces, se podría transmitir, pero la deliberación interna de los jueces, no. Hay diferencias entre México y Brasil, ¿no? Yo creo que produce, no está bien. Transparencia en el nombramiento, o sea, que el Ejecutivo, quien sea que nombre, diga quiénes son los candidatos con antelación, produzca listas, eso yo creo que está muy bien, para aumentar la participación ciudadana, para facilitarla. Y respecto a los nombramientos políticos, esa es la última cosa, yo creo que es muy importante no aislar a las Cortes. Está bien que a las Cortes en particular, las que interpretan la Constitución, las que tienen este poder político fuerte. Entonces, que participen los órganos políticos está bien, porque si no se cristaliza la jurisprudencia, se aísla del proceso político a la Corte que interpreta la Constitución, que es un documento político legal, ¿no? En Colombia hubo durante mucho tiempo un sistema de cooptación que literalmente cristalizó, o sea, es decir, los jueces seleccionaban a sus reemplazos y se cristalizó la jurisprudencia de manera excesiva. Ahí lo...
Thank you. I want to address Mr. Munoz's question about career judiciaries, so judges who spend their entire life exam and then remain as judges, versus recognition judiciaries where someone can be appointed to the highest court after distinguishing themselves in another career. It can be as a lawyer, it can be in academia. So I think the career judiciaries work fine for the technical task of judging. The case for the recognition judiciary arises partly from what highest courts have to do, which may be different. So adjudicating constitutional matters, which are larger questions of policy under most constitutions, which in this region also give extensive rights. So, and then I won't go into all the other questions, but in a way this is the background to them. So the US Supreme Court involves the political branches, and we know that sometimes it's controversial and even damaging to the judges who are appointed, but at least it means that they can then say they've been appointed by the highest decision makers in both of the other branches, so they have that legitimacy when deciding those important questions. Now, elections are another way of giving legitimacy. Councils have been talked about, and the one thought I want to leave there is that sometimes councils can function more like legislatures interviewing in public. It's the whole transparency discussion, and that has been found necessary mainly in those countries where there's been a crisis, there's been authoritarianism, and they want to build confidence in the judiciary, which is low, and then it becomes necessary in the view of some.
Thanks. Time, as I say, is always the enemy. I think for those of you who didn't get a chance to have your questions asked, suffice to say, please do approach our presenters. I am sure there are many opinions among these people, like there are amongst yourselves, and a great deal of expertise in the room. If you join with me in thanking our presenters, and then we'll break for coffee and resume again about 11. Thank you so much.